5 seconds to go. Start. It is submitted that Regulation 44 can in no manner can be construed to mean that it permits all outsiders except lawyers. It is submitted that this is so since the basic principle is that an employee has no right to representation in the departmental proceedings by another person or a lawyer unless the service rules specifically provides for the same. It is submitted that right to representation is available only to the extent specifically provided for in the rules. Reliance is placed on the decisions of this court. It is submitted that right to representation in the inquiry can be restricted, controlled, or regulated by the statute, service rules, regulations, or standing orders, and the extent of representation in any inquiry has to be in accordance with the statute, service rules, regulations, or standing orders, etc. In support of above submission, reliance is placed on the decision of this court in the case of Cipla Limited. It is further submitted that as held by this court in the case of Bharat Petroleum Corporation Limited Supra, there should be minimum intervention of any outsider legal practitioner in departmental proceedings, and the choice, if granted by the statute, service rules, regulations, or standing orders, cannot be allowed to travel beyond the statutes, service rules, regulations, standing orders. It is submitted that in the present case, the service conditions of the employee of the bank are governed by Regulation 2010, which do not contain any provision enabling the candidate under the inquiry to have any defense representative outside the employees of the bank. It is submitted that the object and purpose of Regulation 44 was to keep a check on frivolous and unnecessary requests made for legal practitioner if the facts and situation do not demand so. It is submitted that handbook procedure issued by the Vigilance Department of the bank, which was duly approved by the board, also do not allow the employee to choose any outsider or a legal practitioner as his defense representative, and the same is expressly provided under clause 8 of chapter 8 of the handbook procedure. It is submitted that the impugned judgment and order has created an anomalous situation where ex-employees who themselves may have been subject of a disciplinary inquiry, charge sheeted, dismissed from service, are also enabled to act as defense representatives. Ex-employees who were part of vigilance or audit sections who come across a lot of information of confidential nature are enabled to act as defense representatives, which would result in grave injustice. the solemn nature of proceedings is taken away and would result in issues of order lines as well as decorum when a disgruntled ex-employee is enabled to act as a defense representative. CVC Circular Number 19th September 2021 dated 6th October 2021 prescribes the time limit for completion of departmental inquiry within 6 months, and the same has adopted in the Vigilance Handbook page number 55 para 7.2. If an outsider gets permitted completion of departmental inquiry within prescribed time limit shall be a problem. Stop.